whose plan do you want to have in place? You want the government's plan, or do you want your plan? I ask clients that, and they don't quite understand what I'm asking them. But when you have an estate plan, just like any other sport, I mean, you're either playing by the rules that the sport sets, or if you've got another set of rules you want to play by, that's what you can do when it comes to estate planning. So then it becomes, well, what do you want to do? Do you want to go by the state's rules, or do you want to go by your rule book? And most of my clients will say, well, I guess I want to do it by my rule book. What am I allowed to do? And it's like anything else. You need to know what the rules of the game are. And in the case of estate planning, if you have no plan in place whatsoever, then you're setting yourself and your family up so that a probate court judge is the one who's going to have a big say in what happens to your stuff, your estate, your property, how your kids will inherit what you have. Alternatively, if you set up your own plan, then you're going to be the one who's going to have a big say in how your stuff is passed to your family. And then, people start to grasp it and understand, well, okay, yeah, I really want to have more control in how my stuff passes down to my kids. And so there's basically, there's 4 things that I tell people that they want to have then. And I said, if that's the case, you want to have a plan that directs your property to get to the people that you want to have it the quickest way possible, the most tax efficient way possible, and the cheapest way possible. I said, when it comes to, getting it the cheapest way possible, that the state's plan is not going to be the cheapest way for you to get your property to your kids. It's also not going to be the quickest, because anything that the state gets involved with, anytime any government gets involved, there's going to be cost and there's going to be delay. So those are 2 biggies right out of the box that you can eliminate. The cost of probate is going to be about 5 to 6% of the gross value of the assets. So by having your plan as opposed to the state's plan, right out of the box, you're going to save your family about 5 to 6% of the gross value of everything that you've accumulated. And you think about it, if you've accumulated an estate over 20 or 30 years, or built a business over 20 or 30 years, you want that to go 100% to your family as quick as possible with the least cost possible. Why have the state, with their hand in your back pocket? It don't have to be that way. So, having a plan in place that tells, your successor trustee, here's how I want my property managed for these people, and it happens immediately. When you pass away, whoever you've named as the successor trustee steps into those shoes immediately. They get a copy of the death certificate, they file an affidavit of death of trustee and record it with the county recorder's office. They now can control real property. They take, that affidavit of death of trustee, they give it to brokerage account companies, they give it to banks, and they're automatically in charge of everything. Whereas if you don't have that kind of a plan, and you got the state's plan, well, now the first thing you got to do is you've got to get a lawyer to file some paperwork, to file something called a petition for probate that gets submitted to a probate court judge. So it takes about 30 days or so to put that all together and get it filed with the court. And then if you're lucky, the way the court calendars are currently running, maybe you'll have a court date 3 or 4 months down the road. So what happens for the 30 days that it takes to put the petition together and the additional maybe 60 to 90 days that it takes you to get on court calendar? Well, everything's in a hold position. Nobody can do anything because nobody's really in charge until and unless the court says so. And then even in that instance, if someone pops up and says, well, wait a minute, I think I'm the one who should be in charge. Well, now you got 2 lawyers off and running and the fun begins. And everything in the estate starts to get depleted. So from the standpoint of having your own rule book that dictates what happens and who's going to be in charge, eliminating costs and eliminating time delays can be critical. So the other things that go hand in hand with that, I said there are 4 things that you have to be aware of in having an estate plan. Well, the other ones are, you want to make sure that there's a document in place that puts someone in charge in the event you can't make financial decisions for yourself. Because again, God forbid something happens to you, you're in a terrible accident and you're not killed. Well, who steps in and makes your mortgage payment for you? If you're not married, who steps in and makes the mortgage payment? Who keeps the bills paid at the house? Who pays your car payment? Who pays your credit card payments? If you don't have anyone in place to do that, I mean, those bills go unpaid and arrearages start to accumulate, late fees start to accumulate, things get put into collection. So you want to have someone, if you don't have a spouse, you want to have someone in place who's going to address those things for you. And that's what, a financial power of attorney does. That's one of the documents, one of the 4 things that I tell people that they absolutely need. The other one is the healthcare agency form that does basically the medical counterpart of what a financial power of attorney does. And, those directives put someone in place to make decisions for you only if you're not able to communicate or make those decisions for yourself. Obviously, if you're in the hospital and you can blink your eyes to communicate, well, you can communicate. No one's taken your ability to make your decisions away in that event. But if you can't and you're just laying there, you need someone to advocate for you. And so those documents put someone in place to do that for you. And generally, it doesn't have to be the same person. Sometimes people put one person in the financial power of attorney who's going to handle the financial aspects of their estate. And then when it comes to the medical issues, they have someone else who's going to handle that for them. It doesn't necessarily have to be the same person. And then, the other document that I tell people they need to have is what's called a living will. And it's the document that allows physicians to withdraw life support in the event that, you're in a terrible accident. Your body is still working, but there's no brain activity and there's no chance that you're going to come back. In that event, hospitals, doctors, they like to see that document so it relieves them of financial responsibility if they decide to act on someone's direction and withdraw life support from you. And you want to make sure that you've put someone in place that can make that decision for you, again, if you're not able to make it yourself, and that is your desire. I've got documents in place that address that for me, because if God forbid something happens to me and I'm just laying on a respirator with no brain activity, that's no way to live. Years ago, there was a case, some of you may have heard of it. It was called the Terri Schiavo case. Terri Schiavo was a young woman who got married, and on her honeymoon, terrible, I think it was a scuba diving accident that happened. Anyway, she wound up on life support. And her husband at the time wanted to withdraw life support because the doctors were saying there was absolutely no chance of recovery. And she had absolutely no documents in place. She was a newlywed. Her parents stepped in and said, no, you don't, withdraw life support from our daughter. And they were well-meaning. I mean, it was their daughter. Everyone understood. But a legal proceeding started. And actually, that legal proceeding went on for almost 20 years. It went up and down the courts until it finally wound up in the Supreme Court. And the Supreme Court said, yeah, the husband did have the authority to make the decision. At that point, she had been on life support for so long that they withdrew the life support, and she continued to exist because her body had just built up so much of a sustenance that even then she didn't pass away peacefully, and it took a while for that to happen. And I think about that case, and I would not want to be in that kind of position. And I think a lot of people feel the same way. They don't want to be in that position. So having that kind of a document in place gives you the peace of mind, knowing that, okay, God forbid something terrible like that happens. A, it's not going to be a situation where I'm going to find myself in, and B, I'm not going to be a burden on my family because, honestly, I wouldn't want my wife to have to feel compelled to come up and visit me in the hospital while I'm just laying there with absolutely, no ability to communicate or even know that she's there. So you don't want to put your family through that. Just, if that all of us have to pass away at some time. If that's my time, that's my time. And if you've executed documents to address that, they should be honored and carried out. So for that reason, when I say the 4 things, I'm talking about a financial power of attorney, a healthcare agency, a living will, and a properly drafted estate plan. Those are the 4 documents to really encompass, what you need to protect not only yourself, but your family. So again, to bring this full circle, if you don't have a proper estate plan, you're either playing by the state's rule book or you're playing by your rule book. And if you don't have a plan, you're playing by the state's rule book. And you got to understand, the state's rule book means you're going to pay, it's going to be a big delay, and you're going to put your family through a lot of stress and unnecessary cost. So if you want to avoid having that happen to your family, there's a link at the bottom where you can contact me and discuss ways that you can prevent this from happening to your family.